Perspectives, Finding Common Ground, a podcast series that brings together a panel of thought leader perspectives as a forum to socialize and problem solve education technology issues with the goal to ultimately find common ground.
Hello, and welcome to this episode of Perspectives, Finding Common Ground. Today, we're going to be talking about managing student data privacy agreements. Student data privacy is growing in its intensity and importance. The regulations and the requirements are ever expanding. And I've got a wonderful panel here today to talk with us about how to go about, managing these agreements and options and scenarios to doing so effectively. I'm going to start with some introductions. I think we'll go around the horn and let everybody introduce themselves and share a little bit about what their perspective is on student data privacy and agreements. And I guess we will start with Sarah, if that's okay.
Sure. Hi, I'm Sarah Cluck. I'm the Vice President of Education and Children's Policy at the Software and Information Industry Association. I've been here about 7 years. Before that, I was at the U.S. Department of Education in the Privacy Office. So I've been working on privacy in some way, shape, or form in my career for over a decade now. COPPA and FERPA are my special wheelhouse. I'm happy to be here today.
Welcome, Sarah.
Thanks.
Great. Can you introduce yourself next, please?
Sure. Hi, Patrick. Thanks for having me. I'm Louise DeCandia. I'm the Chief Privacy Officer for the New York State Education Department. I have been in this position for about 3 years. One of our requirements in our New York State law is that school districts enter into data privacy agreements with ed tech vendors specifically. So we actually recently became a member of Access for Learning and have started incorporating the National Data Protection Agreement into our schools.
Fantastic. Welcome. And last but not least, Steve.
Thank you, Patrick. Steve Swift. I'm the Executive Director of Access for Learning. I have been in this position for about 9 months full-time. Prior to that, I was the CIO in Cambridge Public Schools, Cambridge, Massachusetts for 17 years, and then another 10 years prior to that in another district. I have been deeply involved in student data privacy for about 15 years, starting when I was in Cambridge and then eventually founding the Student Data Privacy Consortium and now continuing that work as the Executive Director at A4L. So thank you, Patrick, for inviting me, and I'm looking forward to the conversation.
Fantastic. Well, and I can say that I'm grateful to have all of you here, and I consider all of you friends, which is really nice. So this is really, truly a conversation among friends today. I guess probably the best place to start is there are so many different components to student data privacy, so many different regulations. And to just kind of set the stage, Sarah, maybe you could start by framing out what you see those different pieces are and the relationships between them.
Sure. I could go on this topic for a long, long time, but I will just I'll focus on U.S.-based policy. So in the U.S., we have the Federal Student Privacy Law, which is the Family Educational Rights and Privacy Act, or FERPA. That's a federal law that's intended to be the floor for student data privacy. We also have the Children's Online Privacy Protection Act, or COPPA, which is overseen by the Federal Trade Commission, and other civil rights laws that may impact how student data is collected and managed in schools, like IDEA and other laws. And then at the state level, we have many different states with many different laws that are written to some written many years ago, and also many written in the past 10 to 15 years. We have some New York experts on the law, so they can go into education law 2D. But many different states have many different laws intending to protect student privacy and kids' privacy. And those laws vary by state. There's no state. They're all a little bit different. And I don't think I can confidently say any state is the strongest state or the weakest state. They're all different and unique, and that's really how our educational system is built in the U.S., established for local control where local school districts and schools get to set their own policies and procedures, supported by those at the state level and at the federal level to ensure that kids get the best education we can provide for them and that their student data is protected.
One of the things that I think is really unique, and I'll let Steve and Luis talk to this a little bit next. The requirement is not a one-to-one relationship with the agreement that goes into place to cover those requirements. So if you're managing compliance with the statutes and the laws, you can do multiple satisfactions of those compliances with a single agreement. And I think that that's kind of a neat first step in managing the multitude of requirements there is. Steve, can you talk a little bit about the Student Data Privacy Consortium and how it was built, why it was built, and how it addresses these needs?
Yeah, absolutely. So the Student Data Privacy Consortium, or SDPC for short, which is a mouthful, really grew out of the work that I was doing in Cambridge. When I first arrived in Cambridge, like 18 years ago now, the community and the parents were already asking questions about how is their children's data being protected in all these new applications up in the cloud. So I spent a lot of time talking to vendors about the privacy policies and terms of service and figuring out how we're going to ensure that the data is properly protected and building processes within the districts to help manage that. And soon realized that it just doesn't make sense for every district to be replicating this. And, would it be possible to share those practices and procedures as well as a model data privacy agreement that we were asking our providers to sign? So the consortium started by expanding that practice across Massachusetts, and we created the Massachusetts Student Privacy Alliance. So school districts got together and shared those best practices in that one DPA for the state of Massachusetts. And we started to have limited success. So as you can imagine, one state asking vendors to sign this DPA, and realized that we needed to have a bigger impact on the marketplace. And could we expand it across the country? And that's when I partnered with Access to Learning, because they already were a nonprofit with many districts and state agencies and vendor members. It seemed like a good place to potentially leverage that organization to expand what we were doing in Massachusetts across the country. And so now, 10 years later, we have 28 state alliances. So these are official organizations within 28 states that are running their organized student data privacy work and using the tools that A4L provides, as well as a national data privacy agreement, which took many years to develop the first NDPA. And what's unique about the NDPA is that it is a single instrument that provides that flexibility to address the differences across the country that you were kind of alluding to there, Patrick, that, through exhibits, we could have state specific or even in some cases, district specific requirements on the same national data privacy agreement. So when people see it, and whether a vendor or a district, they've seen that document before, and they can easily see where there's anything different from the model instrument that's being used across the country. And the whole goal of this is to reduce some of that complexity and make it easier for districts and vendors to understand what their obligations are when sharing student data, and streamline that process of getting those DPAs in place so that we can get the tools in the hands of the teachers and the educators quickly and know that the data is being protected securely. And Louise can probably go like the next level down into a state and how it's helping them.
You should host this podcast, Steve. You are up north. Louise, tell us a little bit more about how you're working with the Student Data Privacy Consortium to implement this across New York State.
Sure. So when I first started my position, I reached out to the field to hear some of their questions, concerns, the major issues that were, they wanted really addressed by this office and the new CPO. And the number one thing that kept coming back was the data protection agreements. And I would hear from administrators in schools saying, how am I supposed to negotiate a data protection agreement with Google or Adobe? Like, that's insane. I'm not an attorney. I don't have a business expertise. And when you step back and look at it, it is a lot. Not to mention, New York has over 1,000 education agencies, all of whom are responsible to enter into data protection agreements with vendors. So vendors were also annoyed, saying, well, why do I have to negotiate with Binghamton and then 2 weeks later, Albany? We're all using the same product. It should be the same services. And eventually someone connected me with Access for Learning and with Steve, and we're also a membership of an alliance which is based in Massachusetts Tech. And we realized that this was really the right course for us. So now we have one NDPA. New York, as you can imagine, has a very extensive exhibit attached to that NDPA. No matter how we try to get it down, it's still quite a few additional pages. But every vendor knows pretty much what they're getting now, and every school district can rest assured that the minimum terms that need to be agreed upon to comply with FERPA and Law 2D are in that agreement. So it's a much better system. And it can take us a little while to get up and running because we have so many additional requirements in New York. But I know when I go out to schools and talk to administrators, everyone's really excited about the prospect of using this tool.
I think also one of the challenges with that I'm guessing is part of the struggle to on-ramp this is there are diversity in technologies. So technologies may be collecting things or not collecting things. And I know from the company's perspective, making sure that these agreements are representative of what they're actually doing and don't represent things that they're not doing is something I've heard is a priority for them. So making sure that they are saying anything false or misrepresenting what they are doing. They want to make sure that these agreements through the exhibits or wherever are reflective of their actual practices and making sure that they align with New York law and not going outside of the scope of New York law because they want to make sure that they're doing everything, crossing their T's and dotting their I's where they can, that they can make sure that they're not exposing themselves to any additional legal risk.
It's a great point. The perspective that we're missing from this conversation is that of the vendor, and I can pipe in a little bit here and there. It is just as difficult as it is for a school system. It is for a vendor in the ed tech space to manage the regulations. And what I'm hearing here is by centralizing or making more systemic the approach to dealing with student data privacy agreements, both sides are able to lean in harder, invest more in coming up with the best arrangement rather than doing it a one-off here and a one-off there. That makes it much, much more difficult to really do the due diligence that's necessary with this topic and to do it effectively.
Yeah, and I think making sure that it isn't an adversarial agreement either. Like, folks are partners in this and trying to figure out, and companies are supposed to protect their legal risk, and schools are also doing the same. So making sure that folks are entering into these discussions and agreements with the best intentions in mind to make sure that everything is done without too many emotions or stress placed on the participants in the conversations.
Yeah, absolutely. Well, so now we have a framework for reference, something that we can do. Let's talk a little bit. Let's address the people out there that aren't involved in this yet, and raise some of the issues that they may be facing right now. Let's start. I don't like to start with negatives, but what are some common mistakes that are made when dealing with data privacy agreements with technology vendors?
Well, I'm going to take a little, if you don't mind, I'll take it even a step lower and just talk from school districts' perspectives. As much as we have been talking about this for years and preaching about it, I still feel like there is a fair percentage of school districts across the country that are not thinking about the data that's going out in their apps, though they're not getting data privacy agreements in place. And they don't understand that they're not meeting their FERPA requirements because they're sharing data outside of the school district. And when, I mentioned how we have 28 state alliances, what about those other, is it 22? Am I doing the math right? 22 alliances, and what's going on in some very rural areas that we haven't gotten to. And, I worry about inequities of privacy for our students. And, how do we get to all the relationships and ensure that the data is being protected properly? So when you say, what are some schools doing wrong? I'm just saying, what are they not doing? What are they not even thinking about and worrying about?
I also think the work that the various state departments of education or state boards of education have done to build up capacity in the schools with experts or even webinars or resources has been particularly helpful. I know the U.S. Department of Education has also done some work and has some great technical assistance for practitioners that may not have a full-time IT director or anyone full-time on any of these types of this type of work. But also, I think there's a lot of resources out there, and ensuring that we continue to build capacity. And I'm sure there's folks in rural areas that are doing the work and are experts at this, and rural areas, less well-resourced areas, and they're probably smarter than any of us on the phone here that are doing really good work. So I want to not discount the folks that maybe aren't on the radar, but are doing the good work out there and ensuring that their student data is protected.
And Patrick, I would respond to your question to point out that having a DPA doesn't mean we sign an agreement and we walk away. Our work is done. I complied with the regulations, which is really a concern, and that would be a concern probably for me more than anyone else here. And that is one, issue we have entering into the NDPA and having it set forth as a specific format. We want to make sure that people understand what they're signing, have buy-in to what they're signing, and schools are following up on that. So, for instance, in the new NDPA version 2, there is a requirement that ed tech vendors submit an audit once a year. This is one way for us to make sure that our ed tech vendors are maintaining the cybersecurity requirements that we've asked of them, and schools should be following up on that. They should be knowledgeable that that's in their data protection agreement and following up on that. And when we had, for instance, the Eliminate Education breach, we had schools who had valid data protection agreements they entered into with the company, but lost track of the fact that they were no longer using the product or certain aspects of the product, and meanwhile had all this data remaining with Illuminate. And then we're very surprised to find out that 10 years worth of student data was breached, when really it could have been a couple because you didn't follow up with the company, or no data breached. So I think that's my only concern here. I think having a consistent system and a data protection agreement that most of the country is using is definitely a great move in the right direction. I wish it was coming nationally as a requirement and we were all on board with exactly what's needed. But we still have requirements even once that DPA is entered into.
It's fascinating. This is not a school-only issue. I can assure you that there are companies that, to Steve's words, are, what are they not doing? They're not aware. They're not paying attention. Hey, we have to do some testing on our newest release. Who can I plug into and give me some data and we'll work with it? Kind of. I think it's really also important to recognize that there are organizations like SIIA, there are organizations like the Student Data Privacy Consortium that vendors can work with to learn, to get the resources and the assistance that they need. So it's a universal branding. The solution or the direction for support might be different, but support does help. And if you can get it from the state, that's great, but there's other organizations for other parties as well. You mentioned an audit, Louise. I think it's a fascinating challenge. And can you talk a little bit more about that? It's written into the agreement. How do you enforce it? and what's the level of the audit or the complexity of the audit?
Sure, I could talk a little bit about it. We are often looking for a SOC 2 or something equivalent when we ask an ed tech vendor for audit. I can give you an example of what occurred in my agency soon after I took over the position. I do similar roles that LEAs do on an SEA perspective, right? So I make sure we have data protection agreements in place with vendors that we're using that are getting a lot of student data. And one of our vendors, who is big in the education world, was had a takeover and then another takeover and then maybe another takeover. So we said, look, this is already in our agreement with you that we can ask for an audit. We're asking for an audit. We want to make sure we're secure. We're not even sure who the owner is today. So we went back and forth. I can tell you it took years to finally get that audit. There was so much pushback. Where now as an agency, we're stepping back and saying, wait a minute, who is this company? Let's take a better look at them. Why are we doing business with them? It's one thing if this came completely out of the blue, perhaps, but when it's written into the agreement and or if you had a breach, I think any vendor should be completely willing to work with the LEA or SEA and say, yeah, we're gonna do an audit. We're gonna work with you and show you where we stand.
Fantastic. Sarah, can you talk a little bit about the resources that are available for vendors to ensure that they're being compliant and the guidance that is provided to them about supporting, Louise and her peers throughout the country?
Yeah, there are a lot of resources. I think that the diversity in companies and the diversity of services that they're offering are also something to keep in mind as you're looking for these resources. The U.S. Department of Education is the place where I always recommend go first. Understand the basics, understand what FERPA is, what the Protection of People Rights Amendment is, what that means for you as a company. They have some great videos, handouts, and I wish they published more of their findings letters, but that's for another question. That's for another conversation. The Future of Privacy Forum, we at SIA work to provide our members with resources, knowledge about what's happening, keeping our members up to date when there's new student privacy laws even. For example, Ohio passed one just in the past couple of months. So we help our members stay aware of where things are happening, what's going on, when things aren't passing, what Congress is doing, to try to stay ahead of it so you aren't surprised when somebody comes and says, hey, we need you to sign an agreement, we need you to do an audit, we need you to do X, Y, and Z, here's what's in the law, here's what's in the regulations, here's how it maps out, just to keep folks up to date on that. And then going to the state agencies, going to in New York, the BOCES, figuring out how local districts and regional support centers are handling some of this issue. Like I said at the top of this podcast, our educational system in the U.S. has always been based on local control. So local entities setting their own policies, own practices. I think that's where we might find some tension with a national data privacy agreement where states or local districts decide to set up their own practices. And I know there's exhibits and opportunities to update and align for specific state, but ensuring that the local districts have a say in how things work and how student data is protected as long as it aligns with state and federal law, I think is really important. And some of the resources provided by the state, BOCES, local districts are really helpful to make sure that the agreement align with the expectations of parents, students, and community members.
Good. We talked about a lot of the current status. Let's talk a little bit about where things are going. What are some of the changes that we expect, and what do we think people should be leaning into to make sure that going forward they're covered, they're doing the right things, and they're doing it as efficiently as they can. So you got a whole bunch of agreements, but what's next?
Well, Patrick, I can let you know that New York State, when our Education Law 2D was passed, which was in 2014, it does have a big section dedicated to enforcement. It authorizes a commissioner and the chief privacy officer with the commissioner to take enforcement against third-party vendors. I think as we get the law up and running and the regulations written, there was a lot of hesitancy to do that, but we are really moving forward with taking some action and using that enforcement tool now. We have a few cases that we resolved over the summer. We have a case pending with Illuminate, with our Attorney General's office. We settled the case with College Board about 6 months ago. So, and when I talk to people in the field, no one's particularly angry or upset about the idea of moving toward enforcement. I think it's sort of a natural progression in this area to say, we've made these agreements, you understand what was required of you, you still didn't uphold your part of the bargain, so this is really the next step in the process. So I think it'll be interesting to see what people think of New York's initiatives in enforcement and whether other states follow through and do anything similar.
Well, before Sarah responds to the enforcement piece, I just had two thoughts that when you asked about what's coming up. And one of the things that we've been focused on when you were talking a little bit about the audits and Louise was talking about a SOC 2 audit was the fact that, auditing for security controls is difficult because there really is no standard requirement across the country of security controls. New York has specific requirements. Some states do, Texas, Illinois, New Hampshire. But in absence of that, there's nothing for a school district to say you must implement this 800 or whatever. So we tried to get out in front of that by creating what we call the Global Education Security Standard, which is a crosswalk of controls, existing frameworks. So we didn't create anything new. We just spent a lot of time doing that crosswalk and identifying the controls that were applicable for educational technology, leveraging the work that was done in Australia and New Zealand already, with the goal of, again, making it easier for everyone. Much like the NDPA was bringing together vendors and districts for common privacy obligations, we wanted to identify the common security controls. And so we all had the same target. I don't want people to think that, even though I came from a district, that the consortium is, just districts looking out for districts. It really is vendors and districts working together. And we've heard from our vendor members as much as the districts that they need a common set of security controls to implement because it's just crazy to get all these different requirements. So that's one thing that I think about is in the future. It would be great if we could all be on the same page there. I'm just going to throw it out there because it's what you hear about all the time. The other big thing is AI and its implications on privacy. And, you could spend all afternoon talking about it. So I'm just going to stop there, that it is something we have to be thinking about moving forward.
You're just going to throw out AI and just leave it at that. I love and just say, we don't have to talk about it. Let's just move on. It's another day.
Yep.
It's like throwing a ball on the playground full of kids saying, don't touch it.
Yeah. Yeah. Steve threw a softball over to me to respond to the enforcement thing. Enforcement statement. And I think enforcement is a really important tool that state, the federal government, any sort of enforcement agency has here. I think it's especially important, to go after bad actors because we need to deter them and ensure that folks aren't taking advantage of kids, or schools or parents or teachers. And I think that's why I mentioned earlier, it would be really helpful if the U.S. Department of Education issued more findings letters so that we could figure out and see how they are helping resolve FERPA complaints. And I think it's really important for practitioners. I think it's really important to offer some clarity to ed tech companies and to schools to better practices. And I think that there are a lot of good actors. There are a lot of companies that are working to do this right, a lot of schools that are working to do this right. It's not easy. we're dealing with student data, and schools need to have student data to report attendance, to report how students are doing, to report all sorts of things. And companies help them collect and manage that student data, and figuring out how to ensure that the good actors are the ones in the school helping the schools, and the bad actors are not in the school, not having access to student data. So enforcement has an important role here, and I am glad that that's a component of our judicial system. Just generally speaking, it's just a good thing to do. Make sure that people can't do things outside the scope of law.
To just push a little bit further, in terms of statutes and new statutes, what do you see on the horizon, just as a little bit of a forecast? And are these statutory requirements getting better? You had mentioned before different technologies have different concerns with regards to privacy. So a two-part question. It's where are the policies going, and are they getting better, especially given changing technology?
Can I offer the "it depends" answer that we often like to do in educational privacy? I think that on the horizon, we're seeing a lot of kids' privacy laws, kids' privacy proposal. New York State is considering a couple, has started, the AG's office has started the rulemaking on a couple children's privacy, children's safety laws. And how those impact the education system is still unknown. And whether the technologies used in the schools will be impacted, and how those will be impacted, I think it remains to be seen. The rulemaking just kicked off, and they're just doing the first round, so it's going to take some time to figure things out. But how vendors are going to need to figure out, are they going to have to comply with 2D? Are they going to comply with CDPA? Are they going to have to comply with Save for Kids? Or is it going to be some mishmash of all of them in New York? And the same goes for the federal government. The same goes for all across the states that are considering kids' privacy laws. How can schools effectively manage student privacy and ensure that they're meeting their obligation? How can parents know what to expect in the schools versus at home, or when there's the devices are going back and forth to school? Where are we going to draw lines? Where do we need to have some gray area? I think over the next couple of years, we're going to see either changes or murkier waters. So that's why I said it depends. There's no clear answer.
Sarah, thanks for bringing up the SAVE Act and the CDPA in New York. I actually just finished putting our comments together yesterday for the AG's office. And I just finished writing an article for our newsletter trying to point out to schools, a lot of legislation is coming down. There's a lot of movement in this area. There's a lot of cell phone bans in many states. New York considered it over the summer. I haven't taken action yet. But there's a lot of pushback to technology, right? Since Frances Haugen was a whistleblower for Facebook, we have CDPA, and we're behind in other states that already had laws regulating technology and social media for children. They all sort of come into play. Like, I think schools should not necessarily, you don't have to be an expert on CDPA in New York. Focus on FERPA and 2D, please. But you should be knowledgeable about this and take a look at the big picture and see that there is a lot of serious concern about the amount of technology we are putting in front of our children and students. And it's all going to come into play with each other. Are we being protective with ed tech vendors on the school front? And are parents, really inserting their role with all these laws and making sure that they understand how often their kids are using social media, and are they taking control of the consent provisions they have under these new laws? So I think schools should really be paying attention to the much bigger, wider picture here.
And I think there's an important role, because schools are often, parents and students look to schools as role models. They can help through this and navigate technology, as folks have done throughout the years, navigating music, navigating any sort of new technology that's coming out when kids are in school, given whatever decade. I think schools can play an important role to ensure that things are done well and that students are prepared for whatever they decide to do after they're in K-12 schools. And helping them become good digital citizens, good general citizens, knowing how they can recognize whether something is generated by AI and what that means. I think there's important tools that students are going to need to be able to, their capacity is going to be able to be built up. So ensuring that the technologies are there to help them learn, but also schools are able to have that, whatever professional development and tools and resources are needed to be able to provide that sort of leadership and guidance for students and families.
Yeah, I mean, ultimately, schools are providing consent on behalf of parents to use certain products and tools in the classroom. And that is a very large role to have. And these other laws are coming out saying, hey, parents, we want to make sure you have consent when your child signs on to TikTok or other social media platforms and you're aware of it. But here we have to keep in mind that schools have that role when the student is in, K-12, 9 to 12. So it's really an important role that schools have to understand that they have and that they've taken on for the parent, and that it really cannot be abused in this era where we're really contemplating technology use with children.
Sarah and Louise captured it really well. I mean, it's a really interesting and complex issues we're dealing with right now. And I don't know where it's all going to land, right? The intersection of parents' rights and students in school. And I think the only other thing I want to add is that as these bills are drafted and written, it's really important, and Sarah alluded to this, that, folks from the education sector have input into it because of the unintended consequences. If, like Louise said, a bill is passed, parents have the rights to, have their students deleted from any online app. How does that impact classrooms and things like that? So I think it's just really important that we play a role, or we insert ourselves into get our opinions, and like you put your comments in, Louise, on the current drafts, so that we don't have those unintended consequences that really disrupt good education with good tools in classrooms.
Great. Well, so we have just a couple minutes left, and I intentionally left the AI discussion to the end because it easily can turn into a volcano of thoughts and discussion. But I'd like to frame it a little bit because we've talked about technologies are different. We've talked about the evolution of what's happening here, but very specifically, we have a current kind of explosion in the awareness and consideration of adoption of AI tools, generative AI tools in classrooms and the impacts that they may have. What do you see as the best way to manage through data privacy agreements what's going on? What are the priorities to address that? And what are the biggest risks?
Just a small question, Patrick.
Yeah.
So I think that this is something that folks are trying to figure out, right? I think there's no clear, this is the way to go, because I think there's generative AI, and then there's AI that are providing other tools. There's machine learning. There's AI that isn't used in the classroom, but is used by the administrative offices. There's, as I was talking about diverse technologies, there's also diverse uses. So are we going to have an AI tool that helps us manage our cybersecurity at the school to detect data breaches? That might be something that is helpful. Are we going to have an AI tool to try to think of something really crazy, but if I say it, then it'll come true. So I'm or it exists already. So it's an AI tool that does something really nefarious. I don't think there's a bright line between how to deal with AI. And I think if we put AI is bad in one bucket and AI is good in another bucket, then we're going to miss out on some of the things can help students, but also maybe miss some of the students that are some of the things that are going to hurt students. So I think there's some really good work being done through the EdSafe AI Alliance, through Teach AI and other groups that are coming together with diverse perspectives from the broad community on how we navigate building AI policies at the federal level, at the state level, and within school.
I would agree with Sarah. I think there's some great guidance out there. New York actually has not put out guidance, and in large part because we evaluate different states' guidance as it comes out. North Carolina comes to mind quickly, a really outstanding guidance document. Future for Privacy Forum, what to consider when you're using an ed tech company that's using AI, what you need to think about contractually. And Koshin has come out with some great guidance. And one of the first steps in that guidance is you probably need to have some kind of work group or organization within your LEA. I know we have one in the state education department in New York to talk about AI, what products, what uses. To Sarah's point, it could be that you want to use an AI product for your cybersecurity, not necessarily worried about student use of a specific product. So it encompasses everything we do at work in all areas, right? Not just student data privacy and security. I really think the first step would be to set up a work group and have people talk and vet and bring what they know about AI to the table and really figure out step by step what you as an institution are going to do and how you're going to incorporate AI into your daily functions.
And we put together some principles. I should not forget to mention these, but you can look at our industry principles for the future AI in education at edtechprinciples.com. We released those last October. And really, we know it's a baseline, but we wanted to start somewhere. We are hopeful we can continue to work on those as things move forward.
Only thing I'll add is, in the meantime, while you're digesting all the guidance and all these AI bills are being drafted and eventually come out, getting back to the topic of today was managing DPAs, right? And I think the initial narrower focus of just DPAs and AI is really thinking about how your student data is being used. And it is an AI using your student data and sharing it that it shouldn't be. And sometimes it's an in-depth conversation with the provider too, to really understand how they are leveraging the student data in the AI or not. That's what I think we need to be thinking about as districts and vendors.
Great. I'm going to try to summarize this in a moment. Before I do, does anybody have any parting thoughts, any additional contributions they think that we missed or would like to share?
I am looking forward to having this conversation again in a year to see how things have changed.
Or likewise. Yeah. Okay, well, great. This has been very, very rich. And I think it starts with the fact that the challenge has layers of requirements that, there's state and they're federal and state and local. And clearly a system can help manage all those requirements and manage the agreements that we have to deal with here. It's a challenge on all sides, and it takes a village to address it. And when I say it takes a village, it's the schools and the ed agencies, as well as the vendor community. But then it also is the schools and the parents. And there's multiple parties that have to be involved in this to manage it properly. Also, our current state says that too many people on all sides of this equation are not doing enough yet. And we need to get everybody involved, need to make sure that they're aware of and focused on doing the right things. The DPA, the having a data privacy agreement, is really only the first step. You have to have that in place, and then you have to make sure that it gets enforced. And we do see some more of that coming, greater efforts there, enforcing the agreements that we have in place. But the landscape is also evolving. So it's not just we have to go reinforce what we have today, but we have to continuously modify this to move forward and make sure we're addressing it as technology changes. And we talked a bit about AI, but ultimately what I think we all have to bear in mind is that we have to start from the fundamental place of protecting the student data and doing that in an environment that still maximizes their learning. So these have to be structured in a way to make sure that they're consistent, and our efforts need to be structured in a way to make sure we're consistent with that ultimate mission. You guys have been great. Always enjoy it, and as I said at the top of the discussion, I consider you all friends. I'm so glad to have you here, and I do look forward, Sarah, that doing it again in a year, and let's see how it's changed.
Great. Thanks everyone.
Thank you.
Thank you.
Bye-bye.
For now, we'll see you for next time.
Thank you for listening. ClassLink is proud to be the meeting place to facilitate these conversations. If you have a topic idea, send it to perspectives@classlink.com. To keep hearing our perspectives, be sure to follow us on Apple and Spotify, and subscribe to us on YouTube.